Judge Merriweather, you've been nominated to the Court of Federal Claims, is that right?
Yes, Senator.
How many motions have you argued in the Court of Federal Claims? How many cases have you tried in the Court of Federal Claims? What is the, tell me the grounds for granting a new trial in the Court of Federal Claims.
Welcome to Liberty, Watchtower, your front row seat to the pulse of American politics. Here, we cut through the noise to bring you sharp, timely updates, in-depth analysis, and bold commentary on the issues shaping the nation. Whether it's breaking news from Capitol Hill or grassroots movements making waves across the country, Liberty Watchtower keeps you informed, engaged, and ready to think critically. Subscribe and stay tuned. Freedom starts with awareness. Now, let's dive in. Appointing federal judges in the United States is a serious and highly scrutinized constitutional function involving both the executive and legislative branches. Under Article I of the U.S. Constitution, the President nominates federal judges, and the Senate provides advice and consent by confirming or rejecting those nominees. This process often includes public hearings before the Senate Judiciary Committee, where senators assess a nominee's qualifications, judicial temperament, legal knowledge, and readiness to assume the responsibilities of the federal bench. The transcript in question comes from one such hearing in which Judge Merriweather has been nominated to the United States Court of Federal Claims. While less well-known than Article I courts like U.S. District Courts, or Courts of Appeals, this court plays a critical role in adjudicating monetary claims against the federal government. It is sometimes referred to as the People's Court because it allows private individuals and businesses to sue the U.S. government for breach of contract, takings under the Fifth Amendment, or tax refunds, among other claims. Established under Article I of the Constitution, the Court of Federal Claims differs in several important ways from typical federal courts. It conducts bench trials only, no jury. It has a specialized docket involving complex civil matters, especially federal contracts and procurement law.
Congratulations to each of you. Judge Merriweather, you've been nominated to the Court of Federal Claims, is that right?
Yes, Senator.
How many motions have you argued in the Court of Federal Claims?
I have argued hundreds of motions involving complex civil claims in numerous courts. The Court of Federal Claims is not one of those courts.
Okay, so the answer is 0?
That is correct, Senator.
Okay. How many cases have you tried in the Court of Federal Claims?
I have tried a civil case in the District Court for the District of Columbia. Most of my cases have been resolved on motions. None of those cases have been in the Court of Federal Claims, although they involve similarly complex matters under civil laws.
So the answer is 0?
That is correct, Senator.
What is the, tell me the grounds for granting a new trial in the Court of Federal Claims?
All of the trials in the Court of Federal Claims are bench trials, and the Court of Federal Claims, although it is not bound by the federal rules of civil procedure, its rules mirror those rules when applicable. So it's my understanding that the same rules that would apply in the district court are also applied in that context. But if I were presented with a motion for a new trial, should I be confirmed as a judge on the Court of Federal Claims, I would, of course, consult the rules of court of the Court of Federal Claims.
So what are the grounds for granting a new trial?
My understanding is that a new trial, you would have to comply with the applicable rules.
I know that, but what are they? What are the grounds? You said that the rules are identical to the Court of Federal Claims and Federal District Court. I'm not sure that's accurate, but just tell me what are the grounds for granting a new trial in the Court of Federal Claims?
Senator, that is not an issue I have had occasion to consider before, despite my extensive civil experience and my familiarity, not only with the federal rules of civil procedure, but I've also reviewed the rules of the Court of Federal Claims. But if I were presented...
I'm sorry. Go ahead. No, you go ahead. You go ahead. Were you through?
I did not mean to speak over you.
That's okay. You go ahead, and I want you to finish your answer.
So I would, if I were presented with that question, should I be confirmed, I would, again, consult the rules and follow the precedent.
All right. Let me be sure, Judge, I understand your testimony.
It follows its own procedural rules, which mirror but are not identical to the federal rules of civil procedure. Given the unique jurisdiction and technical nature of the Court of Federal Claims, nominees are expected to be well-versed in civil procedure, contract law, and federal procurement issues. Senators often ask pointed legal questions during confirmation hearings to evaluate a nominee's depth of knowledge and readiness to adjudicate complex cases. In the exchange, the senator poses several foundational legal questions, such as the grounds for granting a new trial and the definition of a contract of adhesion, to assess Judge Mayweather's practical familiarity with the kinds of legal issues that come before the Court of Federal Claims. Despite having extensive experience in civil litigation more broadly, the nominee appears unable to clearly articulate specific answers to these questions, raising concerns about preparedness for the specialized role. These hearings are not merely about academic knowledge, they are intended to reveal whether a nominee has the judgment, clarity, and command of legal fundamentals required for a federal judicial appointment. The inability to answer questions about common procedural mechanisms, like motions for a new trial, or basic contract principles, like contracts of adhesion, can prompt skepticism from senators, especially when such matters are central to the role being considered. Ultimately, the goal of such confirmation hearings is to ensure that nominees to the federal bench possess not only legal experience, but also the intellectual rigor and legal fluency necessary to uphold the integrity of the judiciary and fairly administer justice.
Can you tell me one single ground for granting a new trial in either a federal district court or the Court of Federal Claims as we sit here today?
Yes, if you misapplied, if there were gross misapplication of the law, certainly a litigant would argue for
Anything
a
else?
trial.
There are like 6 or 7 of them. Can you tell me any others?
Trials are so infrequent in the civil context, and although I have presided over bench trials and a jury trial, I have not been presented with a motion to have a new trial.
Okay.
So I've not.
Okay. What's a contract of adhesion?
A contract.
Excuse me.
Senator, I'm familiar with contract law, the concept of contracts of adhesion.
Yeah, you're going to say a lot of that. That's what Federal Court of Federal Claims does. What's a contract of adhesion?
Senator, the Court of Federal Claims does handle a lot of procurement cases. Those typically turn on interpretations.
Yes, ma'am, but I'm going to run out of time. What's a contract of adhesion? If you don't know, just tell me.
Senator, despite my extensive civil experience, including dozens of cases that include contract cases, I have not dealt with the question of what a contract of adhesion is, but should it be presented to me,
Sure,
I would.
you'll look it up. Okay. Do you remember